Mr. Mauller. Proceed.
Good afternoon, Mr. Chairman, fellow board members. I'd like to thank you for the opportunity given me to speak here today. It is truly an honor. Well, first let me introduce myself. I'm Jody Mauller, organizer with the International Brotherhood of Boilermakers. I'm come here today in support of many of the proposed rule changes, but would like to speak specifically about rules related to matters litigated at the pre-election hearing. Although I'm not an attorney, I have had the opportunity to review how the time spent at pre-election hearings by the parties impacts workers seeking to do what is central to the act, and that is vote on their desire regarding to be represented by a union. Specifically, I'm here to speak in support of the board implementing the 20% deferral rule. This is a rule that makes sense in the context of a campaign and an election, and as I understand it, the rule would defer any issues of eligibility that affect fewer than 20% of the bargaining unit until after the workers have had the opportunity to vote. This rule would advance allowing workers to vote and to do so in a timely fashion. In my experience, it is also difficult to hear the frustration of workers awaiting the election. They are often frustrated with the process and the length of time it takes for an election to go forward. I've seen workers become discouraged, disengaged, and repeatedly ask, when do we get to vote? I am sure many of my colleagues here are familiar with addressing those frustrations and the difficulty of doing that, especially when the holdups are questions that relate to just a small percentage of workers and their eligibility to vote. I think the fact that many workers have voiced these concerns is indicative of the need for change. Whether you are for the union or against, there is no reason to unnecessarily delay an election from going forward. With the 20% rule, the focus of the election turns back to what is important, and that's giving workers an opportunity to vote regarding their desire to be represented by a union in a fair and timely manner. Everyone here knows that the longer it takes to get to an election, there's more potential for problems to arise during the critical period, and I would submit that holding the election in a more timely manner, which this 20% rule would help achieve, would also help the board, general counsel, regions, and some regions more effectively utilize their resources. Instead of spending days and sometimes weeks at pre-election hearings, litigating and putting on evidence regarding issues that affect only a small percentage of workers, elections could go forward and workers can vote subject to challenge. In conjunction with other rules, this is a sensible approach. Why engage in days and weeks of litigation regarding eligibility and inclusion matters when the focus should be on the workers and their desire to be represented? I think everyone agrees that the focus of the election should be on the workers, and there's no question in my mind that the 20% deferral rule, as well as other rules, will help ensure that this remains the focus. I've reviewed outlines regarding the rules, and I would agree with the assessment that the rules will help prevent this unnecessary and oftentimes wasteful litigation. I believe pre-election hearings often result in significant and unneeded delay. The opportunity to cause this delay, whether it is intentional or not, should be prevented, and the rules, I believe, help in this regard. As mentioned by the AFL-CIO in its comments submitted to the board, the proposals would not permit parties to introduce evidence concerning an issue that is not relevant to the statutory purpose of the hearing, such as the eligibility or inclusion of small numbers of employees. I've recently had an experience where a significant portion of the pre-election hearing was spent taking evidence on the supervisory status of a small percentage of team leads. Certainly, had the 20% rule been in effect, significant time and resources of both the parties, the region, could have been spared. And I am convinced that the election, in conjunction with other rules, would have proceeded in a more timely fashion, instead of taking over 70 days. The supervisory issue could then have been addressed if necessary after the election went forward. Overall, I believe the proposed rules can make a real difference going forward, and it makes sense to implement the new rules. Having elections scheduled at the earliest possible date ensures that workers have an opportunity to vote without significant delay, and the 20% deferral rule is one such rule that will help everyone focus on what is important, and that is the workers, and giving them a fair and timely opportunity to vote on representation. And again, I thank you for your time and consideration.
Thank you.
Thank you. Sorry about the air horn.
Yeah, me too.
Okay.
I just have one question. In your experience, you're sort of juxtaposing the litigation of the team leads with the opportunity to vote. And so could you put those together for me and describe for me sort of the voters' interest in having the team leads issue resolved?
I'm sorry, maybe I misunderstood your question.
Yeah.
But the team leads in this particular instance, if memory serves me correctly, the unit we petitioned for, if I remember correctly, was 151 workers. The team leads, I think, were 12. So it amounted to about 8 or 9%. And I think that if we didn't have to spend time at the hearing discussing something that takes 8 or 9%, composes 8 or 9% of the proposed unit, we could have gotten to an election faster, and the employee or the workers there would have stayed engaged and possibly had a different outcome. I'm sorry.
Was it your experience with that the workers' views about how they would vote in the election were dependent on the eligibility of the team leads?
No, that wasn't. I think mostly the workers are just focused on they want to be represented by a union. And I think more of their frustration was on the fact of the length of time that it took to actually get to exercise their right to make that determination.
I just have one follow-up. What percentage of the unit employees who voted in that case did the team leads interact with during the campaign period?
If I understand your question, your question, all of them.
Okay.
They interacted directly with the workers on a daily basis.
Okay. Thank you.
You're welcome.
Okay, now in your experience, have you elected not to take on a supervisory issue when presented during a pre-election matter?
No, Mr. Chairman, not in my experience. Not that I recall.
Okay.
Sorry.